Thank you for taking the time to attend the webinar today. We should be done in 40 or 45 minutes. The thrust of this webinar is outside of work activities and how that affects the workplace. Janelle Matuszak is going to be a co-presenter today. She's an attorney who has been at the law firm of Bugbee & Conkle for about 15 years. She practices primarily in the area of Ohio workers' compensation law, but she also delves into some other areas, assisting in the labor and employment section, and most recently handling some juvenile cases. My name is Carl Habekost. I'm chairman of the labor and employment section at the firm. I do workers' compensation, employment law, and workplace safety law, specifically OSHA cases. We want to let you know our malpractice carrier will be glad that I'm telling you that what we're going to talk about today does not constitute legal advice, so we don't have an attorney-client relationship. We're just going to give you some general information on some topics.
This is Janelle Matuszak. We're going to start with this employment liability slide. Thanks, Carrie. And actually, the topic for today is when employee conduct outside of the workplace and how that affects terminations and such. But the first thing I'm going to talk about is workplace violence. But this applies because you have to look at the subject of the violence, the reason for the violence, and it often starts outside the workplace to decide if there's a compensable workers' comp claim. The subject of the fight has to be work-related in order for it to be compensable. But if the subject of the violence, as it most often is either a man or a woman, so if your employee is sleeping with his coworker's spouse, that's not work-related, that's something outside of the work. And so anybody injured during that fight would not be entitled to workers' compensation coverage. Intentional tort, as you know, employees, if they're hurt in the workplace, they're covered by workers' comp. There are some sort of situations where an employee can sue their employer directly for an intentional tort, but it has to be pretty egregious. The employer is not liable unless the employee can prove the employer committed the tortious act with the intent to injure them, or with belief that the injury is substantially certain to occur. So if there's some kind of violence inside the workplace, you cannot sue your employer directly, unless maybe with the exception if it was your manager or the owner that committed some sort of violence on the employee, that might be subject to intentional tort.
As we move through the slides here, we're going to touch base also on discrimination issues, employment litigation matters, and what employers can do to mitigate the risk and reduce your risk of any sort of legal action. So I think we beat this slide pretty good. Let's move on to the next. So I did touch base on quite a bit of this. The thing that you need to be considered, or you need to consider when you're talking about protecting your employees, is protecting them from recognized hazards. So if you have a group activity that is held perhaps in the midst of a KKK rally or some other, political event or protest, I think that depending on how what that event is and how it's being managed, could be a recognized hazard. So you're putting your employees in the way of a recognized hazard. But that's really the key in any workplace violence situation, is whether or not you have a recognized hazard. Now, I think the next slide brings to life a real fact pattern out of the files of Bugbee & Conkle. We had a client where an employee was in the midst of marital problems, and the husband was sitting in the parking lot, usually every afternoon, an hour or so before she was scheduled to leave her job. It was a public parking lot. Other businesses used the parking lot. So there was no way for the employer in this instance to have that husband or soon to be ex-husband escorted out of the parking lot, at least at this moment, because he had not done anything illegal. So what advice would you give to your people if you're an HR person or you're a safety professional for an organization? If you're in some kind of management position, you have responsibility to protect your employees. So how would you handle a situation like that? Well, there's really no blueprint for it or no directions. So what we advised was the client contact the local police and at least put them on notice of the situation. So they've done their due diligence. They contacted the local police force and said, here's the situation. We knew they probably weren't going to do anything about it. I did say, ask them to at least send a police cruiser through the parking lot if they could between the hours of 4 and 5 o'clock. And they did do that periodically. Well, what other steps should an employer take in this instance to protect their employee? It does not involve directly the workplace, but you have an employee who's being exposed to danger. So we recommended that they have a male coworker escort her out to her car and make sure that they at least could see her get in the car and drive out of the parking lot. So at least the employer has done what they can to protect the employee in that instance. And this graph shows that women are at a considerably higher risk of death due to work-related homicides, and it's extraordinarily different. I mean, it's 3 times higher for a female to be exposed to death at a work-related homicide than it is a man. So, you have to take that into consideration as well. Those are facts, and facts can be a nasty thing when you get in a lawsuit. So you should be aware of facts, because the facts will provide you with a hazard that you should recognize. Okay, I think done with that slide. As Janelle is going to talk about, Ohio is an AtWill state. So what does that mean, Janelle?
Okay, AtWill State means you can terminate your employee for any reason, and the employee can quit for any reason, generally. There's exceptions to that. That's the next slide. The biggest group of exceptions is under Title VII of the Civil Rights Act. If your employee is in a protected class, you cannot terminate them for these reasons. So you cannot terminate someone for their age if they're over 40, I believe. You cannot terminate someone because they're pregnant, that kind of thing. The weird one here on the screen is genetic information, which doesn't come up very much. They added this in 2008. But if you have an employee that you learn has a certain genetic disease, something like that, you cannot terminate them for that reason. I was talking to Carl about when this would come up, and he said if your health insurance is going to go up if somebody contracts a disease or develops it later in life, maybe somebody would want to terminate them for that. You cannot do that. And religion, country of origin, race, those kind of things. On the next slide, again, private employers can terminate their private employees for any reason at all, except for those under Title VII. You also cannot terminate an employee for being a whistleblower or in retaliation for things like filing a workers' comp claim or filing a discrimination action under the EEOC. You cannot terminate someone because of their disability, and you cannot terminate someone for using their FMLA time.
Yes, I know. And for the audience members, I'm probably driving Janelle crazy because I'm coming up with all of these fact patterns and scenarios that we never talked about. But here's something that just popped into my head, Janelle, and it comes out of a case that we had in our office, once again, an FMLA case. So when you mentioned that you should not terminate or cannot terminate legally somebody for using their FMLA, what if somebody lied while they were off on FMLA as to the reason for their absence? And what I'm going to say is a case, this is one of those true things, truth is stranger than fiction. Somebody was off on FMLA leave because they claimed that they had a concussion and the doctor needed the person to take some time off. The employee completed the paperwork and he was off for, I don't know, I think it was about 10 weeks. Came back to work, and two of his neighbors knew where this guy worked, and they called up his employer and reported the fact that this guy was bragging to them that he was fixing his porch while he was off work. What he actually did was tore the front porch off and rebuilt it and put on an entire front porch. Fortunately, I guess would be one way to look at it, the employer got notice of this before he actually returned to work. So they were able to establish by surveillance that he was actually working outside of the restrictions that he had provided to them on the medical forms. And they terminated him for basically dishonesty. So even though he took the FMLA time and he was away from work, his activities were inconsistent with the medical restrictions that he had represented to the company. So he was terminated. The case went to court and the jury upheld the employer's position. So even though somebody is taking leave, if you have in your policy a well-written handbook policy or leave policy that dishonesty in using the leave can be cause for termination, that's a big help in cases like this. And at will, you can terminate somebody with the exception under the National Labor Relations Act. If your employees are talking about wages, hours, terms, and conditions of employment, that is protected activity. So terminating them for talking about the fact that somebody makes more money than somebody else, you're going to get in trouble for doing that. So just be aware of that. Do employers have rights? That's the question. Can out-of-work activities ever result in disciplinary action? For example, what if you have a drug policy and somebody smokes marijuana outside of work? And you have random drug testing and they test positive for smoking marijuana. The THC shows up on the drug test. Is that just cause for terminating the employee? Here's what the problem is. In Ohio, yes, it is just cause. If you're out in Oregon, Washington, California, New York, I think even Massachusetts, no, that is not just cause. So you have federal law, at least up to this point as of today, on December 16th. Under federal law, cannabis, otherwise known as marijuana, is an illegal drug. It's a Schedule I drug right up there with heroin, LSD, everything else. So it's clearly illegal. So many states have made it legal medically, and even more states now, more and more often, are making the use of cannabis or marijuana legal for a recreational standpoint. And that, so now you have a conflict of laws. Federal law says one thing, the state law says something else. So you have to be very careful. If you're doing business in different states, you need to be aware of what the state laws are as well as the federal laws. And the reason I used marijuana is because it's such a very clear example of outside of work activities. What about political activities? What if somebody is a member of a political group, I don't know, let's just say, and libertarians, and you don't like libertarians? Can you discipline somebody for being a member of the Libertarian political party? Once again, you have to check the local laws. There are laws that indicate in certain states that is expressly prohibited for the employer to discipline somebody for political activity. And this even gets to running for political office. Now, some employers don't like the fact that their employees are not using every waking moment and amount of energy to work activity. So running for political office takes a lot of time and energy, and frankly, it does begin to identify the company with a certain political party. So some employers don't want that. However, at least a dozen states prevent employers from, I guess, telling somebody that they can't run for political office or participate in politics in that way. Also, as amazing as this may sound, there are laws on the books that prevent employers from influencing votes. So New York, I'm throwing New York out there because they pop up quite a bit. New York, California, Illinois, those states have specific laws that prevent employers from, I guess, hassling employees for how they're voting. We will get into this a little bit more later on, but how people talk on social media and how they post things and how they talk in the workplace about politics and other sorts of things that may or may not be protected activity. There's one thing that comes up periodically. If I'm arrested for DUI, for example, it's not called that, it's like operating a motor vehicle under the influence. If I'm arrested for that but not convicted, can I be terminated or can I be disciplined by my employer? In Ohio, the answer to that is yes. In other states, as I indicated, employees are protected for their out-of-work activity. So it just depends. We're sort of throwing this up for you so that you have issue spotting capacity. So you can spot potential problems before you take an action that's going to get you in trouble. Normally at this point in time, I would ask everybody to raise their hands and throw out any questions that you might have or ask you how you're doing. But since this is a webinar, we're just going to keep plowing along. Janelle and I will tag team this slide, although I'm going to do most of the talking. When we say outside of work activities, what do we mean? Well, here are some examples. Attending rallies and parades, either for or against marijuana, LGBTQ parades, KKK and white supremacy parades, political rallies. Those are the type of outside of work activities we mean when we talk about rallies and protests. Well, how about this one? And this has come up with some of our clients. Wearing and displaying company logos at a Black Lives Matter march. how does the employer handle that if they do at all? Or what if somebody comes from a Black Lives Matter rally and wears the hat or the t-shirt into the workplace? How does the employer handle that? What do you do when we're talking about social media posts? And Janelle will talk more about that. You can either talk about it now or later, Janelle. Doesn't bother me. And the big one coming up, Janelle and I are going to have a podcast on this in January. What do you do when you have employees who violate the law as far as COVID-19? They're not wearing masks or facial coverings. They're not social distancing. Essentially, they're partying like it's 1999, and then they have to come into work the next day. Do you have any rights as an employer? Do you have any way that you can protect your employees from potential pandemic virus? So, Janelle, do you have any comments you want to make now, or do you want to hold them in reserve?
Well, I've got a good example on that COVID-19 issue. There was a local high school principal who was photographed at a large event in the middle of a crowd without a mask on. And it went around on social media between the kids, and eventually a lot of the parents saw it. And that's a good question. He wasn't acting as a principal at the time, but he was in the public and a large group of people without a mask, and parents were concerned that he was going to come back to school because school was in session. They did have in-person classes and infect the kids. And what the school did is, without mentioning his name, they sent around a letter to everyone in the district saying, if a staff member was found participating in a large event with more than 10 people, not exercising social distancing, that they would have that person stay home for 2 weeks to quarantine. And that's what they did there. And I think that's entirely appropriate, because the school or the employer would be the same thing, I believe, in a private office, has a duty to protect the employees if they know this is happening. So if you have an employee who is seen, who you know is doing things like this, you can ask them to stay home for 2 weeks if they're not social distancing and that kind of thing. The social media posts, I'll talk a little bit more about later, but it's really a case-by-case basis on whether you can terminate the employee for what they post on social media. It's kind of a hot topic. But in general, if they're talking about terms and conditions of their employment, they cannot be disciplined for that. If it's more of just personal gripes, they can be disciplined. And like I said, we'll talk about that in another slide.
Good.
I think that's everything. Yeah.
What this slide is simply informational, and it's sort of like a billboard. These are the issues we're going to talk about from now until the end of the presentation. So this is a topic slide. Next, we're going to cover unemployment, First Amendment rights, and that means the right to free speech. Religious freedom in the context of workplace and how that bleeds into the workplace, and what rights does an employer have, if any, to manage that. Freedom of association, we've touched base on that a little bit. Is it my right to associate with white supremacists or the Black Panthers? I mean, does the employer have the right to regulate that activity? The ADA is the Americans with Disabilities Act. There's also the ADAAA, the amendment to that act. And then finally, the National Labor Relations Board, and that is the adjudicatory group which manages the National Labor Relations Act. And you've heard us talk about that in terms of the wages, hours, terms and conditions of employment. Okay, unemployment. The bane, other than FMLA, this is the biggest gripe that I have heard over the years from human resource people. Unemployment cases. They're such a headache because they're so time consuming and riddled with people saying things that maybe aren't accurate and frankly may not be true. It's difficult to respond to that when you're at a hearing and there really are no formal rules of evidence. So in that regard, it's similar to a workers' comp hearing, but it can be more intense because the human resource individual took a lot of time, made a lot of effort, sometimes to keep this person employed, and they did not follow policies and they were terminated, and now you have to deal with the aftermath. So in unemployment cases, and this touches base with outside of work activities, if you're going to terminate someone for what they're doing off the clock outside of work, the general concept is the analytical point is the reason for terminating that individual. Does that seem reasonable to a person of ordinary intelligence? In the law, we have this phantom person called ORP, ORPP, ordinary, reasonable, prudent person. And that's just somebody walking on the streets that looks at XYZ company and goes, boy, did you terminate Joe Smith for just cause, just because he took a swing at somebody at a protest? Now, let's assume that that was all on video, that Joe Smith taking a swing at a protester at a parade or a rally was on Channel 11 News at 6 o'clock. That's one thing. But if Joe Smith took a swing at somebody and it's on the news at 6 o'clock and he's wearing XYZ company uniform, that puts the company in a very poor light. So I think a regular, ordinary, reasonable, prudent person would say, yeah, that's a good cause to terminate somebody. Off-duty harassment of employees. Janelle might get into this a little more when we talk about social media. From my experience as a workplace safety individual and attorney representing companies, the off-duty harassment of employees, if it's not addressed properly, elevates into workplace violence, and somebody can get hurt or somebody can get shot, and killed. So off-duty harassment of employees needs to be taken seriously. And the best place to get started with that is in written policies, would be your handbooks and policies that talk about representing the company. We're glad you're an employee. You're fortunate to work at this great organization. We do not tolerate harassment of your coworkers in any fashion. We have zero tolerance for that. Something along those lines. That gives the company then a basis to discipline employees who harass other employees out of work hours for off the workplace. I heard a kind of an interesting definition of discipline. In today's world, we think discipline as something bad, but discipline's root word comes from a Latin word called disco, but that word means learn. So discipline is actually a learning process. You're teaching your employee, and that employee is learning behavior and habits that the company expects from their employees. And harassing coworkers off duty is not something that any of our clients likes to see in their employees. So My mind, yes, take it seriously. If you terminate somebody for that, it's always fact specific, but if it's done properly, you should be able to win that case. And then once again, compliance with safety regulations. We just talked about workplace violence, probably beat it to death, but it's becoming a bigger concern. I've been doing this 30 years. 30 years ago, we didn't really talk much about workplace violence. Now it's becoming an annual topic of conversation in every seminar that we do. School shootings, people coming into the workplace, shooting people. I mean, it's just a problem. So I tell our clients, your job is to protect your employees. Your employees are your biggest asset. Worry about the ramifications later, but if you focus on protecting your employees, 95 to 99% of the time, you're going to be fine. Janelle, I think you do First Amendment, right?
Yeah, thank you, Carl. First Amendment rights, everyone knows First Amendment is freedom of speech. First Amendment also covers freedom of press and freedom of association, but we're going to cover freedom of association separately. A lot of people think that they can't be terminated for something they say because they have a First Amendment right to speak their mind. But that only applies to public employers. That only applies to public employers. So if you work for the government, you do have a First Amendment right for freedom of speech. But if you work for a private employer, like Bugby and Conkle, you can be terminated for things you say. You cannot assert a right to freedom of speech. Now, an exception is if there's an NLRB exception and it's a protected activity, which again, I'll cover more in that last slide.
All right.
And I was just going to say, Carl, lead into the Title VII protections too. Go ahead.
Yes, thank you. So Title VII, as Janelle said, that goes all the way back to 1964. President Lyndon Johnson and the Congress enacted an historic Civil Rights Act, the purpose of which was to protect certain classes of employees in the workplace. There is a concept under Title VII protecting the employee for religious beliefs. Religious freedom is a hallmark of our country. There is a historical way of looking at the founding of our country that talks about freedom of religion. The Pilgrims came over here because they wanted to worship as they felt like worshiping, and they didn't want to have some king or duke or whatever tell them what religion they had to practice. So religious freedom just seems to be inbred into our genes here in America. There is certain limits on that. And anytime you have a right, that has to be balanced against the good of the greater group and has to be balanced against competing interests. Proclaimed racist and anti-Semitic remarks are not protected. Now, I say that hesitantly because it can be certain types of religious language can be protected in certain instances. But the bottom line is that hate speech is not considered to be a religious activity, and it's not protected activity, plain and simple. And I would, at this point, I'm going to bring it up. I know we're coming up on 45 minutes, so Janelle and I appreciate you guys hanging on and listening to us talk. But there's more that goes on here when we're talking about freedom of speech and regulating that in the workplace than simply violating somebody's constitutional rights. Just to be clear, constitutional right means that we are protected against government activity, not private activity. So our law firm can regulate speech in the workplace because we're a private organization. However, what if I was at a church? Or what if I was at a nonprofit organization? If I don't take some concern about certain types of speech, that might affect our nonprofit status. So certain type of political activity and speech activity can affect the tax-exempt status for certain organizations. So if you have somebody out there wearing, if you happen to be working at a tax-exempt organization, they're called 501c3 organizations, and they're wearing a uniform that clearly identifies your company, and they are going on and on about a political position, and it happens more than once, it can be inferred that that individual is talking on behalf of the organization. Now, the IRS has taken the position that tax-exempt organizations cannot get involved in political activity. So that means that if you don't talk to that individual and take whatever action you need to stop that individual, it can be inferred that therefore that individual is, in legal terms, is an agent of the organization and is lobbying on your behalf, and you can lose your tax-exempt status. So I'm only throwing that out there. It's probably, most of you are probably chewing your fingernails going, when's he going to stop talking? But I throw that out there because this can be a more serious matter than simply getting somebody upset because you don't let them talk about what they feel like they need to talk about. And here's the other thing. If this activity is going on during work time, how do you think that affects productivity? Does that really increase productivity or does it decrease productivity? Employers have a right. You have rights. You have rights to expect that somebody comes in and they're going to work. I mean, you're paying them, and it's a two-way street. It's hard to get good employees now. I'm sure all of you know, my God, it's almost impossible to get employees to come in and work regularly, and to where you can depend on them. So at least in our experience, employers aren't running around trying to fire people left and right for no reason. And the alternative is you're entitled to expect somebody to come in and do a good job. So if they're sitting around talking about ongoing political activity, and there are two things you shouldn't talk about with other people, religion and politics. It's just a kindle that can erupt into a big fire. So, you need to also consider that in the workplace. But at any rate, that all falls in under Title VII protections and when we're talking about religion and religious freedom. So hate speech is not protected.
All right, freedom of associations. This goes hand in hand a little bit with that prior slide. Talks a little bit about rallies. So freedom of associations, I think of the case that was cited in the prior slide, which actually had to do with somebody being a member of the KKK. Can you fire somebody for being associated with a hate group, or some other kind of group you don't agree with? Well, freedom of associations is covered under the First Amendment, so public employers cannot fire employees for that reason, but private employers are not subject to the First Amendment, and at least, and it's different in different states, but at least in Ohio, you can terminate someone. There's no protection for someone being a member of a hate group or any other kind of group unless it falls under one of those Title VII protections such as religion.
The ADA stands for the Americans with Disabilities Act. That is a law that was enacted to ensure that individuals with disabilities had equal access to the workplace. You'll also notice a different part of that law requires owners of buildings and municipalities to provide access to buildings and sidewalks and all that. So you'll see ramps for people who are in wheelchairs and might be otherwise disabled from walking. So that's why it all falls under the Americans with Disabilities Act. I'm sure most of you know that you should not be terminating somebody because they're disabled. The best way to avoid a problem in this area is to document that you engaged in what's known as the interactive process. That means you talk to the individual, try to find out what their idea of their disability is, whether or not they can perform the essential functions of that job with or without a reasonable accommodation, and whether you have what's known as just cause for termination. That means a reason for termination other than their disability. So when you're talking about taking disciplinary action against someone for outside of work activities, be aware of the disability factor.
Okay, and then finally, the NLRB. This is where we've seen a lot of activity regarding social media posts outside of work. The National Labor Relations Act applies to all employers, whether they are unionized or not. And under the NLRA, you have to allow employees to discuss the terms and conditions of their employment, even if they don't have a union. So if your employees are on social media talking about job responsibilities or their hours, complaining about their health insurance or the dress code, those types of things are probably going to be terms and conditions of employment and are protected, and they cannot be disciplined in any way for discussing those types of things. The NLRB has said that if they're, and gripe is the word they use, if they're simple gripes, those kind of things are not protected and they can be disciplined. So if they're just complaining that their boss is a jerk and dresses funny, or they don't like the way he talks, that kind of speech is not protected. You can terminate an employee for damaging the company with their posts, such as revealing trade secrets, or if they're posting homophobic or racist remarks and linking themselves to the company, those kind of things, they can be disciplined. Carl and I were talking before this, we could have a whole hour about just this issue. So if you have something that you think is sort of on the borderline, or if you're wondering if you can discipline for it, it's really best to talk to an attorney, because there has been a lot of activity on this. And even if you look at the NLRB's guidance, it's kind of all over the place, but they've been really active in this area in the last few years. But the basic thing to remember is if they're talking about terms and conditions of employment, that's protected. You cannot discipline them for that.
Yes, and I believe our final slide, Carrie. So this is sort of a takeaway slide. And this just popped into my head, so I'm gonna say it because it is applicable. Sometimes the weirdest analogies are the ones that people remember. I've been cleaning out an old bedroom, getting rid of old books and stuff so I can have a place at home where I can work. I've been kind of working at the kitchen table and in the basement and everything like that, as I'm sure a lot of you have had to go through the same thing. So I'm cleaning out in what we always called the junk room, and it contained a lot of old books. We had 4 children go through the house, and we had a lot of Dr. Seuss books. And I saw one called Horton Hears a Who. And it reminded me when I counsel clients that if somebody complains about let's say Joe Smith again, and outside of work activities, that's the very kind of complaint that you as managers, human resource people, safety people, you need to be serious about, listen, and document. When Horton hears a who, so when the HR manager hears a complaint about Joe Smith taking a swing at somebody at a parade, at the very least, that needs to be documented, because that should put that person on your radar screen as a potential source of violence. So when I know that I don't have it necessarily clearly here, but document. So do your investigation, collect the evidence, document the activity, such as violent behavior, and it jeopardizes the safety and well-being of everybody. If you have 100 employees, 99 employees are important to take care of. If you have one bad apple, it can ruin the whole bunch. So there can be outside activities that jeopardize the entire organization. You retain the discretion to terminate an employee for any lawful reason. You don't have to list every single reason. So we pulled this from a handbook policy. The company retains the discretion to terminate the employee for any lawful reason not specifically listed herein. So just because a reason is not specifically listed, you can't possibly list everything. But you can give yourself some discretion by having this sentence in there. And the reason I'm bringing this up is I had a case go all the way to the Ohio Supreme Court, and the court found that an employee with 42 years of experience as a heavy machine operator was not fired with just cause. Why? Because the company had listed 26 different reasons or examples for termination, but they didn't list insubordination. And so the court, in its infinite wisdom, decided that insubordination was something that a 42-year employee should have specifically been made aware of, or the company should have had a statement such as it retains the discretion to terminate for any lawful reason not listed herein. So that's why we came up with that sentence. Anytime that you're terminating someone, we always recommend you have a witness. If you think there's any potential for safety concerns, have security present, make sure you have an easy exit to get out of there. We did indicate that hate speech is not a protected political activity, but there are reasons why you should tread very lightly when you're going to terminate someone for any sort of political activity. You have to be aware of the fact that employees have the right to talk about and discuss wages, hours, terms, and conditions of employment. That would include on social media and outside of the work. Be aware of the Civil Rights Act, Disability Act. If you're going to terminate someone for reasons of off-duty conduct, cite specifically that off-duty conduct, and those reasons may or may not be listed in the handbook. But if you document and you're specific, you give a reasonable basis for terminating someone, even if it's for outside work activity, you should be fine. All right. Just want to let everyone know that we're going to have a podcast where we are going to go into depth about COVID-19, and we'll continue on with some of the topics we've already talked about. Specifically, what are you going to do if somebody goes to a party, they don't social distance, they don't wear facial covering? How do you handle that as an employer? So we would like to thank you for attending today's webinar. If you have any questions or concerns or further comments, you have our contact information.